One of the 9 justices of the Supreme Court, Esther Chitimbo, yes, Tisache, came out verifiably to accuse President Museveni, one of the respondents in that case, for having conspired with the Chief of Defense Forces to frustrate Robert Kyagulanyi, the petitioner in this Supreme Court case, from actually leaving his home. According to Esther Chitimbo Chisache, she says since President Museveni is the appointing authority, having had the powers to appoint the Chief of Defense Forces, he couldn't have known that the Chief of Defense Forces had ordered security to surround Kyagulanyi's home. And she also says for that reason, it's the reason why Kyagulanyi didn't have enough time to actually adduce enough evidence in court. Well, according to the respondents' lawyers, that is Chiwanuka Chidiowa, you also did have John Tumwebaze, Ebert. They also came out and said the 200 affidavits that were adduced in court by Robert Kyagulanyi, they were too many. And the 6 days needed to interrogate and peruse through all those documents were not enough in that regard. So we are actually taking a look at the drama in the Supreme Court case and trying to bring ourselves up to speed with the latest information in that regard. John Tumwebaze, he is a partner with Kampala Associated Advocates, right? And we also do have Sarah Bidete. She is the Executive Director, Center for Constitutional Governance, with whom we are going to be expounding on this conversation. Very good morning, John Tumwebaze and Sarah Bidete.
Good morning.
John, please bring us up to speed with what is happening within the Supreme Court as far as this case is concerned.
First of all, as far as we are concerned, that case ended on Thursday. So whatever is happening from Thursday, somebody else knows better.
So we are safe when it comes to talking about this conversation?
Yes, yes, the case has ended. The case ended by a withdrawal, first of all. The court allowed the withdrawal and reserved a date for when they would give their detailed reasons. And the detailed reasons were given on Thursday by the panel. And that for me ends the whole case. So what happened thereafter on I think was it Friday, and what could be happening today or anything else is not that case. The court, that court has is a panel. The panel is composed of 9 justices. So even if the 7, even if 4 judges appear without the 5, you won't call it a panel. So, and the disagreements there in the court knows better what transpired. But what I know is that the decision of the court was rendered, and the court adjourned to come back.
That was before midday.
Yes.
Only not to come back in the tent, and then we were surprised. We were there watching Esther Chitimbo Chisache in darkness, no power, the sound system is off, and we're wondering what is happening.
I think
only for her to say that her ruling has been confiscated.
No, I think there has been a press statement issued by the judiciary, because we are not operating in a vacuum. There's been a press statement issued by the judiciary, and you can maybe I need to take off my mask now that you are far from me.
Indeed.
I'll use it. The judiciary has explained the circumstances of the day.
Indeed.
That when they left court, they were under the impression, because you see, the practice, the court will give a dissenting decision, or when you have a panel, there will be people who would dissent. But the practice of the court is that you saturate the whatever decision you want to give. It is from those decisions of all the members of the panel that the head of the panel, who is in this case the Chief Justice, would determine how many people have a majority decision. Are you 8-1? Are you 4-5? Are you 6-3? Then the head of the panel will say, okay, this is now the majority decision, which becomes the decision of the court.
And it seems like by the time of the ruling, Chief Justice Alfonso Winyidolo did not know the position of Esther Chitimbo Chisache because she was withholding her ruling.
No, absolutely. He said, he said, when you look at the statement, said in the morning, before they came to give us the final decision, he asked all the members to saturate their decisions, so that then he's able to determine who are the majority and who are the minority.
And she refused.
And then Justice Chisache apparently said, from the press statement, I'm quoting really from the statement.
Ahead.
You have it.
Yes.
Justice Chisache says, no, my decision is not ready. It's partly typed and partly in writing. So then the Chief Justice said, then I will take it that it is in the dissenting. Because of all the other decisions, they are all concurring. And then he said, okay, since it's not ready and it's dissenting, then let's go and deliver the ones which are ready. And then in the afternoon, you will deliver the dissenting one. After all, we already have a majority. Mind you, even if there were only 5 justices out of 9, that means that you already have a majority.
Indeed, yes.
So then they went and delivered the ones which were ready, which were the majority. And then they adjourned to make sure she comes to deliver hers. And when they went back, they said, okay, saturate the one, your dissenting one, so that we read it. And then we are able to go back. And then she said, no.
She still refused.
She said, I'm not saturating it. That's when the justices said, no.
We are not going back.
We are not going back. Because remember, for you to even, she had had the benefit of reading all the other members' decisions. For you to be dissenting, it means you have read my decision and you disagree with my reasons and my findings, and therefore you are dissenting. Meaning she read all the other decisions. So therefore, and then this is when the justices say, no, 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 no. Without us reading what you are going to present, we can't go back. This is the press statement. This is not my statement. The statement is there. I'm simply paraphrasing. That's what they said. I think you read it. Yeah. So the guy said, no, without reading what you are going to read, we can't go back. And then it is at this point that the Chief Justice invites lawyers into his chambers and says, you can go, don't wait for us, because we are not coming.
Indeed.
It is at this point that the Chief Justice says, you, our staff, correct our files from the tent, because we are not going back. Now what happens thereafter is what you saw. The learned justice coming and the honorable justice coming and says, no, I'm here, I'm reading the statement. I'm reading my dissenting opinion. Now I can tell you that I'm sure she knew, and I know for a fact, and legal minds will tell you, that at that point, what you are reading is maybe an academic document. It cannot be a decision of the court. Because the court is described.
Sada Birete, according to the tradition of the Supreme Court, which also doubles as the Court of Appeal, the judges, the Supreme Court judges, will meet before this ruling. They will talk about your ruling, my ruling, her ruling, so that they could harmonize how many are dissenting and how many are actually for the majority ruling. But then what we saw was Esther Chisache snubbing most of these meetings. It was not one. She did not show up at any of those meetings to let the justices in on what her ruling would be on the day. On the day where we saw her say her copy was confiscated, she goes into the building, comes back with a carbon copy of the Supreme Court ruling. What do you make of all this drama, Sada Birete? Was her ruling confiscated? Do you feel like there was some kind of foul play?
I think it's important that before we diverge into the symptoms of institutional collapse in Uganda, we first address the major problem. Because even when you have malaria and you take Panadol, really that discussing the drama at Supreme Court is taking malaria to treat, taking Panadol to treat malaria. We have endemic collapse of institutions in this country. All governance institutions have collapsed at the weight of a permanent presidency. We have a collapse in parliament, and you have seen the drama with the deputy speaker, I think chairing sessions once or twice in a 5-year tenure. You have collapse at executive level, and we have seen drama at the different events. And now what is happening and what we are attempting to discuss today is the climax of collapse or crisis in the judiciary. Because the drama at Supreme Court is not an isolated event. A lot of fights have been happening, internal fights. And when you have internal fights in an institution,
since 2013,
it requires, leadership with magnanimity. Because the true moment to test, the true character of a leader is not tested in moments of comfort and convenience.
It's in moments of strife.
Of controversy and of strife. So what we are seeing at the Supreme Court is the collapse, the crisis in the judiciary, the failed or struggling leadership of the Chief Justice, And the collapse of governance institutions in this country. We saw the drama that happened at the Electoral Commission and the kind of electoral output we have put. So this drama is not isolated. But having said that, you see when you have institutions that cannot function properly, then there's nothing, the citizens are on their own. The citizens are basically on their own. You have institutions that cannot check, that cannot function, that cannot exercise true separation of powers. And that was confirmed in the Friday's Constitutional Court ruling, where the executive fuses the judiciary in unconstitutional appointments.
We shall interrogate
so this
that
is
later.
Yeah, this is the crisis we are dealing with. But the conduct of Justice Sache, or even the conduct of all this Kyagulanyi petition, because even this climax of crisis at the judiciary is not isolated. The time Kyagulanyi filed the petition, I'm sure if you asked an ordinary citizen on this country, in this country, on the confidence levels in court, they have drastically dropped, because these hearings were public and everybody was seeing what is happening. The hostility in court, outright hostility, outright bias that led to the withdrawal, the collapse of that petition itself, was part of the crisis. So then you have a climax of the fights, of the disagreements, because there is a disagreement with a dissenting judgment. Yes, it is a tradition for panels, for quorums in court to share judgments, to discuss and attend meetings. And there is a disciplinary procedure structure in the judiciary. So when you read media reports, they say that Justice Sache has not been regular in attending these meetings, in the way she works with her colleagues. So one then asks if the judiciary is functional and able to check itself. Why didn't the Judicial Service Commission check those behaviors? Because what kind of administration of justice, which in accordance to Article 26 is supposed to be administered in the wishes, interests, values and aspirations of the people. I mean, what kind of justice have they been dispensing if their working relationship is like what the public is witnessing? So to me, it is a collapse of institutions and a failed leadership that we should discuss in these institutions, and not symptomatic issues that are happening and being propelled in the media.
Of course, we also do know that this is not the first time Esther Chisache has been dissenting in her rulings. Remember the issue of the rebel MPs, fast forward 2013, who were chased up by the Constitutional Court out of Parliament. And then Constitutional Court was telling Esther Chisache these issues were not appealable. The same judge came out and said, no. We do not monitor what happens in the Constitutional Court, but the issues brought forward are appealable. And that's how Barnabas Tinkasimira, Wilfred Nwagaba and the others went back into Parliament, because of a dissenting ruling by Esther Chisache. Fast forward 2021, she's telling us one of the respondents in the case, Yoweri Kaguta Museveni, was actually involved in the Supreme Court case and everything that happened to Robert Kyagulanyi, especially ordering the Chief of Defense Forces to actually surround his house to make it impossible for him to adduce evidence in court. Do you think she had something right there when she made that statement? President Museveni being involved.
Yeah, Justice Sache is known really as a dissenting judge. Yes. Commonly, I think she rarely agrees with colleagues. I think this is one of the progressive judgments that, in my view, really, that she's dissenting about. Because her two main points was that the legal team should have been given more time, given the circumstances that happened to the petitioner.
Indeed.
And caused by the respondents, not by his own making. And that is confirmed in a High Court decision that nobody has appealed. Two is the ruling that, condemning people to costs, which is a creation of the Presidential Elections Act, is unconstitutional. So I think those are really very progressive decisions that she has made. And in my view, it is, you know, it is one of the progressive decisions that she has made in her dissenting ways.
All right, I also have John Tumebas. He's a partner with Kampala Associated Advocates. When Sarah Birete was making her submission, all I could see from your facial expression was dissatisfaction. You were nodding in disapproval. Why, John Tumebas?
First of all, she gets it wrong. One, I don't want to hold His Lordship Justice Sache for dissenting.
Yes.
That's normal. It is the way you do it that is abnormal. When
you ambush your colleagues.
Yes, exactly. Because when you don't give me your decision, and yet it is supposed to be a decision of the court. By the way, even the dissenting decision is a decision of the court. That's why you deliver it in the presence of all your colleagues. Even the majority decision, even if you are 5-4, because they are 9, you must deliver it in the presence of the whole panel. That's why you saturate it, so that they read it and say, we disagree with you.
Yes.
But this now, because we are the majority, it is a decision of the court. When you have a justice of the Supreme Court addressing a press conference, standing shoulder to shoulder with a litigant, that for me is the problem. There are ethical issues there.
It's like a saying,
when
was in bed with Robert Chagulanyi and his lawyers.
Your disagreement, that's not what I'm saying. If I wanted to say so, I would have said so.
Flanked by the litigant.
But how did that
Everyone left and Chagulanyi's lawyer.
I think let me finish.
Okay, finish, John.
Let me finish. I just kept quiet so that finish. So for me, dissenting per se is not the problem. You can dissent.
Yes.
But how you manage dissent, disagreement in any institution, and of course I don't want to agree with her that there is a crisis, and these you use these strong words, and I think this is the media. That's where my sister here is quoting from. I saw headlines in the media, crisis at the Supreme Court. No. By the way, we who are in litigation, you are most likely going to find dissenting judgments in that Supreme Court, in the Court of Appeal. But because those are panels, at the High Court, what happens is that one single judge sits, doesn't saturate their decision to nobody, makes their decision. You can even type it on their computer, not even using a clerk or a secretary, and deliver it. It doesn't work that way in panels all over the civilized world. So there is no crisis at the Supreme Court. There was just a disagreement that went outside in the media.
You have a dissenting judge who is saying one of the respondents in the case was heavily involved in actually frustrating the efforts of one of the petitioners.
And that's where she gets it wrong. You need to give this decision of the Supreme Court context. The Honorable Chagulanyi, and you people should have followed this, Mr. Chagulanyi and his team filed a presidential petition within the prescribed days. In fact, they wrote to court and said, we are ready to file our petition on Saturday.
I remember.
Please keep the court open. In that letter, they did not indicate that, please, we are unable to file the petition because we have been failed.
And the Chief Justice told them to come on Monday.
No. No, first of all, get it from there. The man does not write to court to say, I am unable to file because I have been incarcerated. He says, no, I am ready to file on Saturday. Can you keep the court open for me? And the Chief Justice said, no, I can't keep the court open on Saturday. In fact, come on Monday.
Yes.
Between Saturday and Monday, anybody whose petition was not ready, who has told you, by the way, my petition is ready, would have made it ready. Now, Monday came, the man filed his petition. Out of nowhere, I think, and I can tell you for certain, because we did say that the petition was as shallow as they get. I think they realized. From what we later learned, is that they consulted some other lawyers, and the lawyers told them, you guys, what you have filed in court is rubbish. Please change it. Then they ran with the amendment, which was an afterthought. They filed an amendment, an application to amend. Now, except if you want to tell me that because you are a politician, whatever you file in court must go your way. If it goes your way, then the court is not biased. If it doesn't go your way, then the court is biased. Then I don't understand it. The amendment, we fought it and defeated it. It was not allowed. The man now says, okay, if my amendment has not been allowed, I am ready to continue with my case. Please give me time And please mark, it is on court record. It was covered live on TV. The man said, now that I can't amend my petition, give me time to file my evidence. The court said, how much time do you need? The man said, today, which was a Friday, today, if you give me, I will file 50 affidavits. By Sunday, by Monday, close of business on Monday,
Yes.
I will file all the remaining 50 affidavits, which will be the end of my case. The guy is on record, you people. It's recorded. You can replay it here. You covered it. I saw in TV there, covered it.
I remember
you
very
have
well.
it.
I remember very
The
well.
court said, okay, now that you ask for Monday by close of business, we have given you up to 14th in the evening. File whatever you have today. Keep filing. We are going to keep the registry open, even if you have to file. By Monday, by the end of Thursday, the man had filed no single affidavit. By the deadline of Sunday, the man had only filed 53 affidavits. The one he said he would file on Thursday. So we need to give these issues context. It's not a question of the court was biased. That's why I was not shaking my head in this belief. It's not that there was apparent. No. You know, I come here and say, please give me 10,000 shillings for lunch. And then you give it to me. And then tomorrow I come and say, no, I didn't work today because I was hungry. I didn't eat. But you are the one who asked for 10,000. Where did you think you are going to ask to? And moreover, remember there are constitutional timelines within which the court must hear this case. For example, the election petitions which are beginning for parliamentary, the court must hear them within 60 days. There are constitutional timelines, there are statutory timelines which have been set for all these matters happening. Because remember, you don't want to cause a constitutional crisis that my sister is talking about. The constitutional crisis, you cause it by not hearing these cases in time. So the issue of the court being biased is neither here nor there. I have been litigating all the time. We go to court, we win cases, we lose others. Every time you lose a case before a judge, it doesn't mean they are biased. Maybe you had a bad case, and for Kyagulanyi had such a terrible case. In fact, the best decision, the only right decision Kyagulanyi made in all these circumstances is a decision to withdraw his petition. The petition was a non-starter in the first place. It was headed for nowhere. If you are headed for a crash, the best decision to do is to withdraw. That petition would have been dismissed by even a judge who is a beginner. It was going nowhere. It was dead on all principles. It was not particularized. It had no grounds. It had no iota of evidence. It was just a quarrel. You know how you sit down and start quarreling because an election didn't come out the way you wanted it. That's what was happening with Kyagulanyi. So there was no, even the best of lawyers in the world would never have made a miracle out of that petition.
But the miracle was coming, John, and that was the 200 affidavits that were denied by the Supreme Court.
Let me come to the 200. First of all, go to the Supreme Court. Those things are lying somewhere there. First of all, the affidavits were not even 200. They were 117. These are the lies of Kyagulanyi. You know, for the first time, the only thing we actually missed from that petition when Kyagulanyi withdrew it is that we missed an opportunity to show the country the level of lies that Kyagulanyi was involved in. Those affidavits were not even 200. No.
170.
They were 117. Kyagulanyi also told lies, and people should know why Kyagulanyi's application to adduce additional evidence was rejected. It was not rejected because it was the court was biased. No.
Out of time.
It was rejected because that application to adduce further evidence was based on lies. The affidavit in support of that application had said that we came with all our affidavits on the 14th to file them, and the court rejected them because we were late by a few minutes. And the court saw evidence that on the 14th, which was the deadline for them to file affidavits, they came with no such affidavits. That all they came with on that day was received by court. That in fact what they came with on that day were less than the copies the court wanted. Even with the 53 affidavits, the copies which court required, which was about 15 copies, they came with only 7. So the court said you cannot file an application before this honorable court, the Supreme Court of Uganda. This is not the Supreme Court of Afghanistan or any other failed state. The Supreme Court of Uganda. You cannot file an application before court, base it on a false affidavit, and expect it to succeed.
Here's the fact that
It
happened
cannot.
during this election, and SH Timbo actually mentioned it. You responded, that is Yoweri Kaguta Museveni. You had the Attorney General Election Commission and President Museveni. Now, they say President Museveni was instrumental in actually curtailing Robert Chagulanyi's freedom of movement, in that he wasn't able to produce this information on time. He had 4 days after the High Court actually ordered the security to leave, meaning if the lawyers hadn't run to High Court, Chagulanyi would still be at his home. And there would be no Supreme Court petition. Wouldn't you agree, John Tumebas?
That finding is neither here nor there. When you run from your home and get here and start to work, the discussion stops to be about your means of transport from your home. It's about your work now here. We expect you to deliver. Don't tell us that you walked from home or ran from home or jumped from home. That finding is a finding at the High Court level.
Yeah.
Remember, the High Court had Chagulanyi's complaint. That complaint by Chagulanyi of how he was incarcerated in his home, he had taken it to the High Court. The High Court had actually had it. It actually agreed with him that his incarceration was unlawful and even ordered for his
How many days
freeing.
did he
So
yeah.
now you see those number of days
Yes.
don't explain the lies in the Supreme Court. The number of days Chagulanyi was left with don't explain him writing to court and saying, I'm ready to file my affidavit. Chagulanyi could have lost some days. But the man says, I am ready.
John Tumebas
Chagulanyi could
uses
have
an
lost some
analogy
time.
of where
Yes.
Romeo Busiku is leaving home to come to work. It doesn't matter what happens along the way,
He has
I need to
arrived.
come and deliver. But
When
if
you
I
get
have
here, you must
soldiers surrounding my home, I wouldn't be able to leave the house. And that's
let me
evidently
say
that's
it
what
this
happened
way.
to Robert
you
Chagulanyi.
you
Yes.
report here by 6?
I have
You
to be
start your show at what time?
4:30. I have to be awake.
Yes.
Yes.
So I'm sure you wake up at 4:30 and
Yes.
5, but at that time there's no Germany between 5 and 6. But you need like 30 minutes to get here in order for you to start the show. If you found a roadblock and you're held for 2 hours,
I wouldn't show up for
would
the
you
show.
be here
No.
for the show? So Chagulanyi had 15 days to prepare his petition. Originally they used to be 10, and then the Amama Mbaba's petition
Indeed.
helped us have an extension of those days, so that the candidate has enough time to prepare their petition.
Indeed.
So if 10 days were found not to be enough by the same court for the petitioner to prepare a petition,
How will 4 days be enough?
this Chagulanyi lost 11 days, and he's remaining with 4 days. So you can see that honorable, counsel, sorry to call him honorable counsel,
John Tumebas.
he's not even empathetic about that aspect. He's not even bothered, and he thinks it's Chagulanyi's business. And that was the attitude of court, unfortunately. So you have the same court made a finding that 10 days are not enough. Somebody has 4 days, and the hypocritically is saying Chagulanyi wrote that he wanted to fire. In court, you do not have rockers unless you are there. So Chagulanyi thought that let me get to court and then argue my issues, knowing that the whole world knew that Chagulanyi had lost 11 days, because we all knew what was happening. So to say that even the fact that Chagulanyi was, his movements were constrained, and it was not only his movements, he could not even meet his lawyers. Nobody could access him.
That's not true.
Yes, his lawyers could not meet him until they were escorted by police on the 10th day.
That's not true.
No, that is true. They were escorted by police. I mean, these are facts.
Go ahead.
To meet him. So you have these circumstances in the same court that ruled that 10 days are not enough. So you cannot apply for time or write a love letter like Mayambara wrote to that I have interest in taking over the petition. That is not how court business is done. You see, Chagulanyi could not have come to court to say, I need time, unless he was a petitioner. So I think that hypocrisy should not.
And of course, I was talking to Chris Bariomunsi during that same period, and he was tussling it out with the new head of the legal team. And we were talking about why Kyagulanyi did not petition even though he was under incarceration. Chris Barumusi was of the view that he could still have used his lawyers even though he was under
But why
house
was he
arrest.
under incarceration?
Absolutely.
Why was he under and you are a lawyer? How many clients did you meet on phone? I saw you in the Kare Kiura case.
Go ahead.
You were saying you wanted to access your client. Why? Why?
John
You know how law is practiced, and you know how instructions are issued.
I can actually answer. I can give some information to my sisters before she can proceed.
And could Kyagulanyi have petitioned even though he was under incarceration using his lawyers?
First of all,
You could have discussed his petition on phone.
Kyagulanyi, the court gave an order to release Kyagulanyi on the 25th. So let's get the dates right. On the 25th is when Kyagulanyi court issues an order for police to vacate Kyagulanyi's home.
11
and
days
the
later.
elections happened on the 14th.
The elections happened on the 14th.
How many days are those?
So
11.
let me give you just that information, then we'll continue. On the 20th, the police which was at Kyagulanyi's house had a visitor's book where everybody who went to Kyagulanyi's home was signing in and out. The Attorney General of Uganda did swear an affidavit and attach that visitor's book that on the 20th and the 21st, Kyagulanyi's lawyers went to access him. Remember, you guys have a press conference here by Kyagulanyi. There is even one on the BBC and CNN. Kyagulanyi himself saying, I will not, we are still discussing and we haven't made a decision whether to go to court or not.
So that's when the discussion started.
So Kyagulanyi's refusal to go to court and delay to go to court is largely attributed to his indecision. And remember, he started to talk about that public court that time. So, and these things are documented. You see, people forget that whatever you say
So
today.
you believe Kyagulanyi never had an intention to go to court?
He didn't have the intention to go to court. Even a man who is incarcerated, even when they asked him, but you met your lawyers and instructed them to go to court to get for you an order to file an application for habeas corpus.
Can you also give us information on when court vacated the NUP officers?
Which one?
When police vacated NUP officers.
That I am not aware.
Exactly.
And
It took long.
And it was long after even filing.
And I can tell you
so what were the circumstances?
And I can tell you for certain that the issue of NUP's offices and his incarceration and going to court, for example, everything you see in Kyagulanyi's affidavits,
yes,
they seem to have been organized and documented many of the things that happened. Had they had any intention of going to court, because all this is being done, it's a political kind of thing. The Supreme Court was being used simply as a political platform. That's why you see this sustained attack on judges. That's why you see this sustained attack on the court. Kyagulanyi did not have any intention whatsoever of going to that court. Had he had the intention, the lawyers would have filed the application, the petition before. When you claim, for example, that I'm going to file an application in court and then go and look for evidence, that's not how it works. On the day of voting, if you have agents at every polling station, or at least in most of the polling stations, what you are complaining about, the outcome of the election, you will have it on those DR forms.
Where are majority of his agents, by the way?
And that's another lie that was going on around, which we need to correct.
So none of his agents were ever arrested?
None of his team are arrested.
I'm not the arresting officer, so I don't know who is arresting.
You say you are not aware.
Let me tell you for certain. What I know for certain is that somebody keeps claiming that, my witnesses, because this is what was happening in court. It wasn't about my agents. My witnesses are being arrested. Now tell me, before you swear an affidavit and file it in court, how will any arresting officer know that this guy here looks like a NUP witness? Does it mean that, for example, during a presidential election petition, criminal law is suspended?
No, it is not.
Criminal law is not
but
suspended.
Why do we have arbitrary arrests? Are they part of criminal law?
I don't know about the arbitrary arrests.
Go ahead, Tumolas, and exhaust the point.
I don't know.
So that you can also speak.
Exactly. Let me finish this point.
Yes.
When a presidential election is happening, criminal law is not suspended. Thieves are still arrested, burglaries are still happening, everything is being, criminal law is still going on. If I drive badly, they will arrest me for a traffic offense. That doesn't mean that everybody who is arrested then becomes your witness. No. For me, any arbitrary arrest is regrettable. It shouldn't be happening. We should not have arbitrary arrests.
One arbitrary arrest pertains to Robert Chagulanyi, and it was ordered by the respondent, Yoweri Kaguta Museveni. What do you make of that?
No. Are you telling me that everybody who is in prison is a NUP supporter?
No, we are interrogating Esther Chisache's ruling that Museveni ordered the incarceration of Robert Chagulanyi.
You see, I don't want to discuss a dissenting opinion. It's not even a rule. It's not even a judgment of the case. No. That decision by Her Lordship Chisache is an academic paper delivered somewhere. It's not even a decision of the Supreme Court. The decision of the Supreme Court was rendered by a panel by 9 justices with 8 majority opinion. One was supposed to dissent. She could only have dissented in the presence of her colleagues. Without her colleagues, that is not a decision of that Supreme Court. I don't want to discuss it.
Sarah Birete, Esther Chisache, actually you would be willing to actually discuss that issue. Esther Timbo Chisache says President Museveni actually ordered the incarceration of Robert Chagulanyi, and she uses that as a stand for Supreme Court. And she says Supreme Court should have given Chagulanyi more time based on that argument, that Museveni actually ordered the incarceration of Robert Chagulanyi at his home.
He's the commanding chief.
Indeed,
of the defense
and appointing
and the Chagulanyi's house
forces
was sieged by both police and the army. So he can't, he's responsible for the acts of the police and the army in this country. So, but I wanted to
meaning Supreme Court should have given Chagulanyi more time based on those arguments.
Of course, but I wanted to bring out an issue because my co-panelist did say that Chisache was there with a petitioner in the tent. I read in Sunday Monitor in the tent.
At the gate.
That is the next day. Even on Thursday, he remained in the afternoon. There was a petitioner in court. So the petitioner's lawyers. I read in Sunday Monitor yesterday that the Chief Justice, after the 8 judges agreeing that they will not join the afternoon session to deliver, to enable Chisache deliver the dissenting judgment, the Chief Justice called lawyers of the respondent.
All of us.
No, just wait. Lawyers of the respondents. So that is for President Museveni, Electoral Commission and Attorney General. I'm wondering why he never called the lawyers of the petition.
They were there. Please, they were there.
They were there.
We were all called.
They were all.
Even for the petitioner was called. Muyizi was there.
Okay.
This information I can give you.
Yeah, that was Sunday Monitor report, and I found it disturbing.
No.
So, exhaust that.
Okay. But having said that, because I thought that's what explained the presence of the. But thanks for that correction.
Yeah, correction. Yeah.
But having said that, first of all, if this country, because my co-panelist is saying this country is not under crisis, if any person commits a crime, let them be arrested in accordance with the law.
I agree.
Like he said, criminal law is in place. But we have so many arrests, including Chagulanyi siege, that are outside the law. Because if Chagulanyi has committed a crime, arrest him, detain him in a gazetted press, as in accordance with Article 23 of the Constitution. Don't take over his home.
Sarah Birete, okay, go ahead, exhaust that.
Yes. So we have these arbitrary acts by President Museveni. We have abuse of rule of law in this country. And this is part of the crisis that I did talk about. We have drone-speaking people arbitrarily everywhere in the night. I mean, this is the context in which even Chagulanyi claims that some of his witnesses go missing. Because you can't rule it out. People are picked in the night. I think even until 2 days ago, his brother was attacked after midnight. You know, you have these continuing arbitrary acts that are unconstitutional, that are illegal, that are in abuse of rule of law in this country, from pre-election period,
Director,
election
Center
period.
for Constitutional Governance, Sarah Birete. She has not been alone. We also did have Mr. John Tumwebaze. He is a partner with Kampala Associated Advocates, with whom we've been having this conversation on the Supreme Court case that actually ended on Thursday of last week. Gentleman and lady, many thanks for having made the time to speak to us.
Thank you.
And of course, there's also good news. The Constitutional Court actually now wants you, if you're a judge and you want to join a constitutional arm of government or office, you need to first resign your position as a judge. I'll leave you with this clip from Ivan Walunyolo. He's talking about deaths pertaining to diabetes. A very good morning and have a blessed day.